Hi, my name is Kozlowski and I'm an attorney with the Alford Law Firm. Oftentimes people will ask me how to get divorced in North Carolina. North Carolina offers divorce through what's called an absolute divorce. Either party may file for an absolute divorce based on one of two separate grounds. The first ground is the incurable insanity of your spouse, and the second most commonly used ground is the 1-year separation from your spouse. Should you decide to file for absolute divorce based on 1-year separation, there are a few things that you need to know. First of all, the separation period must begin with one party vacating the marital residence with the intent to separate. Both parties must live continuously separate and apart for a 1-year period, and when you file the action, one of the parties must have been a resident of North Carolina for the 6 months immediately preceding the filing of the action. Upon completion of these requirements, either party can file for divorce. Once you receive the absolute divorce, it's very important that you're aware that you will have then lost the right to claim equitable distribution, which is the division of marital property, or alimony through the courts. If you think that you may have property that needs to be divided or that you may have a claim for alimony, it's very important that you assert these rights prior to obtaining the absolute divorce. Minor children are a little different. If you have children that are under the age of 18, the courts will retain jurisdiction over those children until they reach the age of majority. So if you have a claim for custody or child support, you can make that claim or modify that claim at any time during the separation or after the divorce has been granted. If you have questions about whether you are a good candidate for alimony or whether you need to seek equitable distribution to divide your marital property, it is very important that you speak to an attorney before obtaining that absolute divorce. There are other things that you should discuss with your attorney as well prior to filing for and receiving the absolute divorce, such as domestic criminal trespass. When you separate, the party who leaves the marital home will no longer have the ability to return to the home, even if they're on the deed or the lease of the marital home, without the permission of the person who stays behind. The person who stays behind will have the ability to press criminal charges against you for trespassing, even if your name is on the deed. That is very important to remember. So if you think you are considering separating from your spouse, or if you feel that your spouse may be considering separation from you, the first thing I would recommend is to talk to an attorney about your legal rights. By all means, if you have already separated from your spouse, please contact my office so we can set up a consultation. You can reach me at 919-562-0770.